All right. Hello and welcome to the September 24th meeting of the Civil Commitment Standards Work Group. I think we are going to pick up right where we left off last time and jump back into our discussion of client communication. So we had some clarification about where we need to move best practices to, and a note that the conflict check needs to be added at the time of appointment. I'm gonna make this a little bigger for everybody. All right. So sticking with the bold print for 2.1. Is there anything else anybody wants to talk about with that one, or add to, or subtract from that one? I can make my notes bigger so we can see what we've already talked about.
Looks fine to me.
Yeah, I don't have anything else to add.
Great. All right, so moving down to the not bold print, the best practices. Clients detained outside the lawyer's primary county, consider having counsel in the county where the client is detained appointed. Like that was something we all discussed and agreed was a good idea in some cases.
Mm-hmm.
Okay. Any trouble with that language?
No.
Okay. If you have a client detained outside your primary county, seek assistance of an attorney based in the county where the client is detained to conduct the initial interview, which will satisfy the 24-hour requirement. That look right?
I love that, Zoe. That's so funny.
Maintain contact with your clients through any diversion period. I think we're also good on. Reiterating the use clear, developmentally appropriate language. Use the interpreter as required. Encourage clients' participation in their own defense to the fullest extent possible. I think that's the language that we'd agreed on. Okay. And then prior to any meeting with the client, be familiar with the elements of civil commitment. Obtain copies of any relevant documents, the initiating document, recommendations and reports made by other agencies concerning commitment, and law enforcement reports that might be available. Are there any other documents you want to have?
Many hospitals will offer a review of or even copy of the medical records ahead of a hearing being scheduled, even though the statute says 24 hours in advance. I have a relationship with Salem Hospital where they're fine with me requesting and accessing records either through the computer on Epic. I've also looked at paper files. Cedar Hills as well.
Sorry, what is Epic?
It's their program, computer system. It's only accessible on site.
Like
For medical
hospital record
records.
systems.
Mhm.
Yeah, for medical records.
Nice.
Yeah.
Okay. Anything else that we want to add to this one? Good deal.
I would say releases of information are helpful to have on hand for if your client is able to sign for therapist, caseworker, professionals that would have contact with your client.
Okay. How's that?
Yeah.
All right. Familiar with the legal procedure the client will encounter and prepared to discuss the process with the client. And then, are there pre-hearing or pre-trial release options in civil commitment, or is the timeline so short that that's not really a thing?
No. No, if it's a hospital hold, that hold is good for up to 5 business days.
Mm-hmm.
And then a magistrate hold with a warrant of detention on someone in a jail facility, for example. Same kind of thing. You're not gonna have enough time really to have a release hearing prior to a hearing regarding whether they're committed.
Okay. Be familiar with the types of holds.
So I'm getting super nitpicky and I don't have to be. But
Oh,
hospitals
but please do.
can do holds. Courts actually cannot do holds, even though everybody talks about magistrate holds. So maybe types of detention. It's one of my pet peeves that I yell about a lot in Clackamas and nobody listens to me.
Yeah, no, it's correct. It's a case can be initiated by a magistrate, and then they issue a warrant of detention in that case.
Okay. So be familiar with the types of detention that a client may be subject to, the allowable length of detention, and the impact on the type of, that should be the impact of the type of detention, the impact of the type of detention on the client's procedural remedies. Sound fair to say that lawyers should be aware of that?
Yeah.
Deal. All right, and I'm going to tag this as detention, not hold. All right, so I will go back and change hold to detention where we may have it. And I'll check through and make sure that's right. Okay. Anything else in the realm of client communication that you think we should add as a kind of best practice for lawyers to be aware of, to strive for, things like that?
I would say talking to the psychiatrist that's monitoring that person either
Mhm.
prior to or directly after.
Okay.
Prior to
Would
can be helpful because then you know where they're heading. You
Okay.
don't want to, if you can talk to the psychiatrist ahead of time and they can tell you this is just going to be a hold run, we're just going to do 5 business days and be done, 5 judicial days, then you're not scaring your client by telling them. You still have to tell them there could be a hearing because the doctor can change their mind, but it's hard for a client to hear from their doctor, we're going to let you out in 5 business days, and then your lawyer comes in and says they might ask you for you to be committed for up to 6 months.
How about that? Discuss the client's case with the treating psychiatrist to get a sense of the doctor's intentions in the case.
Yeah. That's what I try to do if I can.
Okay. Anything else for this whole 2.1 section?
What do you think about putting in information for client about the timeline and controlling setovers and making requests for setovers? I think that might be a first meeting kind of bit of information as well.
Okay. And this doesn't have to be just first meeting. This can be any meeting with the client, but we will tag that in. So lawyers should be prepared. Including how's that? Be prepared to discuss the timeline of the case with the client at the initial meeting, including ways the timeline may be extended and the client's options during requests for extension by either party.
I mean, in the statute says either party, but in practice, really the only person that can ask for an extension is the client.
Okay.
I don't know how you want to word that, since the statute does say that it can be other people. I just will claim that the state's not ready, which usually gets me somewhere.
Yeah.
This in the statute is kind of up to interpretation, but how I've typically interpreted it is that the hold can only continue if the extension is requested by the person who is subject to a possible commitment or their lawyer, the PAMI.
Yeah.
So if any other party or participant asks for an extension, that's not a basis to continue or for the court to issue a warrant of detention.
I think for our purposes here, if there's a colorable argument that the state can ask for an extension under the statute, whether, there's a practical argument that they do or not, I think we should just leave it at both parties or either party. We can work on kind of practice aids and argument guides and that sort of thing later that have that kind of information in it.
I wonder if I'm okay with that. I mean, I'm not trying to say don't, but I wonder if you just end the sentence at including ways that timeline may be extended.
Yeah, that's probably cleaner.
Yeah.
Done. All right. Anything else to add to the communication with your client section? Okay. Moving right along to the investigation sections. Lawyers have a duty to conduct an independent review of the case, regardless of client's admissions or statements to the lawyer or facts which may justify commitment. Where appropriate, lawyers should engage in a full investigation, which should be conducted as promptly as possible and should include all information, research, and discovery necessary to assess the strengths and weaknesses of the case, prepare the case for hearing, and to best advise the client. Be familiar with the process of requesting funding for an investigator from OPDC, and if they do not have access to an in-house investigator, whenever possible, avoid taking on investigations themselves. that could cause the attorney to be a witness in the case. Lawyer should not, we're using lawyer, not attorney. Lawyer
just
should not
curious.
knowingly use illegal
Sorry.
means to obtain evidence. Go ahead.
I don't have access to an in-house investigator. I don't know if Bailey or Becca do, but usually I don't think the turnaround time would be fast enough to request from OPDC.
I would agree with
Huh.
that. We have in-house investigators, but we have a very particularized process for how to get an investigator assigned to a case. They don't have the time or capacity to handle cases that are this quick of a turnaround unless it's asking for a subpoena to be delivered to someone, or emailed is what they usually want to do if we can. So I
mean,
have, yeah.
I'm not saying it isn't ideal, like, but
Mhm.
Well,
practically,
there is some balance on, we don't want to set a standard that's going to set people up for failure, especially not if it's because our systems can't keep up with the timeline.
because when
wanna
you
do
were
that.
talking about getting in a lawyer in the county where the person is,
Yeah.
I've done that a couple times, but I don't get approval. I mean, I do get approval, but I don't get approval before I have to talk to them
Hmm.
because the approval
Yeah.
doesn't happen that fast.
Right. Or, I mean, even finding an investigator on that quick of a turnaround, let alone getting funding. I've also, because we have so many constraints on how to get an investigator assigned, I've pulled in a law clerk to sit
Mhm.
in. Again, I'm in the fortunate position of being in an office that has law clerks, but really anyone that is in your office that isn't you can
Yeah.
serve as that, but it's just not ideal.
Which doesn't work when you're solo.
Right, yeah.
Oh,
I
I
would
suppose
love
you
to have
could
an
use
investigator.
an
That'd be
admin
amazing.
assistant or someone, unless you're like really solo.
There are practitioners
Which I
who are really
was.
solo, yeah.
Yeah.
I mean, I have a part-time,
I've
I have
done
a
that. It's not-
part-time employee, but I also do juvenile, so she does a lot of my
Yeah.
documentation and meetings when I have to do civil commitments. So, I would love to. I would love that. I just don't have that set up.
Mhm.
We have in-house
So what do
investigators,
you-
but I'm sure I tend more to the side of becoming a witness in my own case. But it's never been a problem. I don't know
Yeah.
if it has for either of you, but there's it is so fast and furious and informal in some of the processes that I feel like that's kind of the way it gets done.
I've never had that problem, and in particular because, I mean, in most cases, I'm speaking to a witness without a witness to witness, which is the psychiatrist, or the investigator. I am not able to bring someone with me to the hospital a lot of the time to witness my conversation with the psychiatrist. So that's just kind of a little, hole that I think we have just because of how fast these happen.
Okay. So what do you do if you have to talk to like a family member? Do you just talk to them and take notes?
That's what I do.
I've frequently just talked to them and taken notes. If it's somebody that I have
Okay.
had concern would tell me a different story than what they told, the investigator, then I'll pull in someone to sit in, but that's pretty rare.
Okay. So let's.
And when I say investigator, I mean the investigator for the county. The
Right.
statutorily required investigator.
This.
Yeah, I am in pretty constant communication with the county investigator.
Mhm.
All right, so take that section out. I can delete it right now because I want to note for my own purposes later. But we'll take out the requesting investigator. I do think we want to leave in the do a full investigation of the case standard. And it sounds like as long as you're doing that yourself, you're fine doing that. Right? I mean, review all the things you need to review and
Mhm.
talk to all the people you need to talk to.
Mhm.
Okay. All right. Let's drop down here. Unless there's anything else you all think should be added to the bold black letter bit. All right. So dropping down to the best practices section. Attempt to interview all potential witnesses in a case, including the investigator for the state's psych, client's family, and other professionals who've worked with the client, as well as any law enforcement officers involved. And here's a question I had: are the clients always arrested?
Mm-mm.
Okay. So let's just
Yeah, that's one way to start. Like if they can be put on a police officer's hold and then that person will take them to the hospital. And then the
Mhm.
hospital is the one that would initiate a civil commitment proceeding. If they decide to place a hold, that's what starts the proceeding. But also someone can just walk into an ER. Or a family can bring them. Yeah,
Or emergency medical services.
right.
And pretty much all of the time, I'm not advised which agency brought them in. I mean, they'll say police or EMS, but I don't usually have enough time to investigate which EMS service brought in my client, get an ROI signed, get that over to that agency, get their records back. Usually I don't want them, but
Okay.
And we also in up in the Portland area, we also have mobile crisis response.
Mhm.
And they can place, well, one of them can place holds, the other one can't. So I don't even have any idea how I'd go about getting their records.
So is it appropriate to leave in the law enforcement EMS officers as people you should be looking to interview, or just pull that and focus on the others in the list?
I tend to focus on the psychiatrist, the family, the investigator, any other witnesses that have been identified by the investigator. Which I mean could include law enforcement. I can't think of a time I've actually directly contacted the law enforcement officer. Um,
Mhm.
and
You
I've
could
never,
change it.
yeah.
You can change it to other witnesses identified by the state. I assume if the police or EMS officer is important to it, they'll identify them. So, assuming people do things often troublesome.
Yeah, I think that makes sense.
Okay. Obtain all pertinent information in possession of are they called the prosecution? Let's just leave it at the state.
Mm-hmm.
At the state, juvenile authorities, law enforcement. I don't know why it has that hanging sentence, including where relevant. Pull that. Encasing Are there cases involving child witnesses or victims?
Hardly ever.
Probably not worth keeping that in this one.
And
And
also,
even in those cases, there's no way we're getting counseling records
Yeah.
that fast.
mm-mm.
Yeah.
Even if we ask for an extension, there's no way.
Do formal and informal discovery, and this is just going to link back to our discovery standard.
Mhm.
All right. So with those changes, everybody good to that one?
Mhm. I don't know that this would be something that you all are doing or should be doing, obtaining prior criminal records and
The
I'd say
only
no.
Yeah, the only time I care is like if they have a current criminal case or if they have, sometimes I look at prior commitments, but I mean, that's on OECI. Like it's not, I don't go
Yeah.
I don't dig into that.
so what if we say lawyers should obtain
Maybe lawyers should be familiar with, I don't
be
know.
familiar with any pending criminal, juvenile cases involving the client and any prior civil. One day I'll be able to spell on command.
So Oregon doesn't allow civil commitments of juveniles.
Oh, cool.
So they wouldn't have a juvenile delinquency case.
Good for us. How's that?
Mhm. Mm.
Okay.
They could have juvenile dependency. They could be
That's
either
true.
a parent or a ward of the
Mhm.
state, because you
Yeah.
can be a ward until you're 21.
Right.
And I suppose those are cases you'd want to know.
Mhm.
A lot of times those are cases I already have. I tend to get those clients.
Makes it easier to be familiar with them, I suppose.
Mm. There's a couple pieces to that, because you have to have OECI access to dependency as well as out of county civil commitment. We have had a huge struggle with getting out of county civil commitment access, which is kind of ridiculous
Mhm.
considering we get the recommits. So we get people who are from all over the state, and we need to know
Yeah.
what their civil commitment history is. And then dependency, I have no access because I don't practice dependency. So I'm not sure what to do there, because I mean, I could tell OECI I need to access this because I might have a client who will have, I will need to know this in the future.
Yeah,
Right.
the only way that I got statewide access for civil commitments was because I was covering cases in other counties.
Mm.
And I said, I will not do this if I have to ask for access every time.
Mm-hmm.
And then I do dependency cases so I can see those. But
Mhm.
yeah, not everybody does.
So I don't know what to do there. We've been trying to get statewide access for a while, and this has not been working for us so far.
Suppose we've got two options. We can leave it as is, and since it is a best practice, it's not going to be a black letter requirement in anything, but is a good idea. We can leave it as that kind of general statement, Or we could add something about OECI access to it, depending on the odds of me practicing civil commitment in the future are fairly low, so
What if folks
you all
think
will have
about
to live with this.
something like, a lawyer should be familiar with any, any other court cases that could affect civil commitment to the best of their ability?
Yeah, I think that makes sense.
That's fine.
Okay. Be familiar with any pending cases involving the client.
I would take out pending.
Okay. Oh, right,
Because-
because
Sometimes they're past civil commitment cases.
Pending
Right.
or past, perhaps,
That's fine. Yeah, that would, yeah.
just to make it
any
clear.
court cases.
Yeah, okay.
I think this whole section is to the best of their ability. So I don't know that we want to reiterate that, but we can reiterate it just to emphasize if you want.
I can't decide. Because I think that it's a different reason why why it's to the best of your ability. I mean, like a lot of it's time constraints to the best of your ability.
Mhm.
And this one's like actual denial of access to things we need because of the system. I'm not saying write that stuff, but
Yeah.
And it seems like it's so rare that it does impact something other than like a pending criminal case that it might not be worth all the explanation then.
yeah, it's usually either a pending criminal case or they're trying to do expanded criteria. And so then they're talking about other cases.
Expanded criteria.
Committed twice within the past 3 years in, I think that's right. And
Similar
exhibiting
circumstances.
substantially similar.
Oh, other reasons they can commit somebody, you mean?
Mhm.
Yeah.
It's, uh, what's chronically mentally ill is what it's called.
Okay. Gotcha.
It's a fourth secret basis for commitment.
Double secret basis for commitment.
Mhm.
All right.
I need to transition
So-
to my phone, just so you know.
Thanks,
I'm gonna
Bailey.
log out and log right back in.
So we can leave 2 for now. We can always come back to this, and I suspect we're going to make at least one more run through the whole document once we get all the wording down that we like. So we'll leave that for the moment. We have the honor around the 3rd day of the case. The lawyer should contact the hospital and state's investigator to confirm the hospital's understanding of the basis for the continued hold. All good there?
Yeah, I don't know that it's necessary. I mean, a lot of us
I
are
don't-
just getting the case on the 3rd day.
Mhm.
I don't usually do that. But
Okay. Is it something we should consider taking out, or is it something that we leave in as a good idea? I mean, when available.
I think you can go out because you're going to get that from other sources of information automatically.
and usually we don't have the report for going to a hearing until day 4.
Okay. I can't remember if it was Bailey who wanted to put this in when we were talking earlier, so I'm gonna leave it for a minute until I get back, and we'll pop back to it. Oh nope. It popped up and told me Bailey had rejoined and then went away immediately. Anyway, so moving on to 4. Consider whether to reduce investigation to writing and instruct investigators to do so only after consultation with the lawyer. If you're not routinely using investigators, I think we can leave out that last clause. The first one's probably still important. Okay. And then don't intentionally destroy evidence. Comply with all statutes governing discovery to the state. All good with those last 2 now?
Yep.
All right. We have time to roll through the experts section before we break at 1. So we have the black letter law of immediately and continually evaluate the need for experts in the case, obtain any necessary expert for either consultation or testimony or both. So let's start with that. Do y'all use like expert witness types or expert consultant types in civil commitments? Timeline seems restrictive for that, but
Do not.
I don't
Okay.
either.
would we be better off reworking this section to talk about how to interact with the state's experts, the doctors? I assume they're called in expert capacity, but okay. Some assumptions work out. Okay. So let's do this. Bump back over. So I find it.
Because I'm being cynical, I'm laughing at that last bolded line.
Whereas do you be familiar with process request funding for experts from us? Yeah. We're still recording, so we won't discuss fun, cynical observations. But let's switch back over to our notes draft. And let's talk about how to work with experts we might actually use on civil commitment cases. So I think we'd identified the client's social worker, the case manager, state's doctors.
Who do
You
we
all are
mean by
not-
case manager?
I don't know.
I think maybe we were talking about like alternatives to civil commitment. Like if you've got somebody in the office who does social worky stuff and can find alternative placements and stuff like that.
Okay. Okay.
Okay.
And I talk to social workers, but I don't,
Mhm.
I never call them as witnesses.
Okay. Even if you're not calling them as witnesses, I think we'll leave them in this section. I mean, experts and professionals. So what, as far as kind of the black letter rule of engagement for working with the, expert or professional folks that you see in the civil commitment realm, do we want something in there for it? Is it like you should always seek out these types of folks? You should always.
I think it's so arbitrary, and a lot
Or
of
is
it
it just-
depends on hospital policy or
Okay.
doctor's personal preference. Some people will just, even if you seek them out, they will not talk to you, short of when they testify. And other people will just get going and tell you all kinds of stuff. So I think it's kind of one of those things you explore often when you're at the treatment facility and you talk to nursing staff or talk to the doctor if they're willing. But a lot of it is going to come down to the hearing.
And a lot of it's
Okay.
case by case too, I think.
Yeah.
Like who is available to actually talk to on, day 4 when that's all you have. So I don't know.
someone's
I
like,
mean,
I just came on shift. I haven't really worked with them. I don't know.
yeah, I love that when they do that.
Right.
I don't know. I mean, it could fall under sort of like the do a thorough investigation. I mean,
Yeah.
I don't know.
And we did include talking to the state's experts in our investigation section. I'm gonna tag this as better saved for later. And we'll just trash that section. Oh, good. I don't have to go back through and renumber everything. All right. So that saves us a few minutes. The next section that we'd want to look at is the discovery section. We got about 10-15 minutes left in our meeting time. So I will put it to you all. If you have something that has to be done right at 1, it's probably better if we break now and come back next time. If you'd like to keep going, I'm game to keep going.
I'm going to have to duck out. I do have 1 o'clock.
All right.
Thank you, though.
So
Yeah, and it'd be weird
let's-
for it just to be me. I don't I don't like that.
Don't like
Codependent.
being the sole authority. Got it. So we will end things here. Thank you all very much for your help and participation today. Just for kind of long-term outlook, we are about halfway through. We've got the discovery section, exploration of disposition without a hearing, and hearing preparation, pretrial motion or pre-hearing motions, and the hearing, and then obligations of counsel following disposition. So I think if next time we can get through the discovery and the disposition without a hearing, then the time after that we should be able to bust through the hearing and hopefully the post-hearing obligations. So that's kind of my big picture plan for the rest of this.
Cool. I try super hard to make these, but obviously I haven't been very good about that.
We really appreciate the dedication to it.
I try.
I know you guys are super busy and this is volunteer work for you. So I do really appreciate it. As I think I've mentioned a couple of times, my knowledge of civil commitment extends to who in my old office was qualified to give a civil commitment case to, and that's the extent of it. So I really could not do this, and the agency couldn't do this without all your help.
Well, let's hope it all gets better before it gets worse. Yeah.
Fingers
All right.
crossed. And on that
Yeah.
note, I will see you all